Louisiana has a landlord-friendly tenant screening environment with minimal state-level regulation beyond the federal baseline. Louisiana's legal system operates under a civil law tradition derived from French and Spanish law, making it unique among the 50 states. But the screening process is governed primarily by federal FCRA, the Federal Fair Housing Act, and limited state provisions. If you're screening tenants in Louisiana, you have broad discretion, though the state's unique legal framework creates some distinctions worth understanding. Let's start with application fees. Louisiana does not cap application fees. There is no state statute limiting what a landlord can charge for tenant screening. Louisiana's landlord-tenant provisions, found in the Louisiana Civil Code and Louisiana Revised Statutes Title IX, do not address application fee amounts, procedures, or refund requirements. Landlords can charge whatever they determine is reasonable. Most Louisiana landlords charge between $20 and $40 per applicant. Louisiana has one of the most affordable rental markets in the country, and keeping fees proportionate to actual screening costs is practical. In a market where average rents are relatively low, charging $50 or $60 for a screening fee feels disproportionate and can discourage applicants. Criminal history screening in Louisiana is unrestricted at the state level. Louisiana does not have a ban-the-box or fair chance housing law for housing. There are no state-level restrictions preventing landlords from asking about criminal history on the initial application. Landlords can inquire about arrests and convictions, can use criminal history as a screening factor without conducting a formal individualized assessment, and are not subject to state-mandated look-back period limits. No Louisiana municipality has enacted a comprehensive local criminal history screening restriction for housing. New Orleans, Baton Rouge, Shreveport, Lafayette, and every other Louisiana community operate under the same unrestricted framework. New Orleans has been more active than other Louisiana cities in discussing tenant protections, and the city's progressive political environment makes additional screening measures a possibility. Landlords in New Orleans should monitor local developments. While nothing comprehensive has been enacted as of this recording, the political conversation is ongoing. Louisiana has provisions for expungement of certain criminal records under Louisiana Code of Criminal Procedure Article 971 and related statutes. Once a record is expunged, it is treated as if the arrest or conviction never occurred, and landlords cannot consider expunged records in screening decisions. Louisiana expanded expungement eligibility in recent years, including provisions for automatic expungement of certain records. Screening providers should be filtering expunged records, and landlords should verify their provider's compliance with Louisiana's expungement statutes. Louisiana legalized medical marijuana, but has not legalized recreational marijuana. Marijuana possession beyond the medical program remains a criminal offense, though the state decriminalized simple possession of small amounts, reducing it from a potential felony to a misdemeanor with limited jail time. Landlords should be aware of the evolving marijuana landscape when evaluating marijuana-related records in screening decisions. HUD's 2016 guidance on criminal history and disparate impact applies in Louisiana. The state has a large African American population, approximately 33% of the state's total population, and criminal history policies that disproportionately affect Black applicants face scrutiny under federal fair housing law. Louisiana's demographics make disparate impact a realistic concern, and blanket criminal history policies that cannot be justified by legitimate business necessity create substantial federal risk. Documenting your criteria and applying them consistently is essential. Source of income protection does not exist at the state level in Louisiana. Landlords are not prohibited from considering the source of an applicant's income when making screening decisions. Landlords can legally decline applicants who pay with housing choice vouchers, Social Security, disability payments, or other government assistance. No Louisiana municipality has enacted a local source of income protection ordinance. Participation in voucher programs is entirely voluntary. This is practically significant because Louisiana has one of the highest poverty rates in the nation, and a substantial portion of the rental population receives government assistance. New Orleans in particular has a high rate of voucher usage. While landlords aren't required to accept vouchers, those who exclude all government-assisted tenants significantly narrow their applicant pool in many Louisiana communities. Many Louisiana landlords, particularly in New Orleans and Baton Rouge, find that voucher tenants provide reliable rent because the housing authority pays its portion directly and on time. For credit reports, Louisiana follows standard FCRA requirements: permissible purpose, written consent, and adverse action notice procedures. Louisiana does not impose additional state-level requirements for credit report access, adverse action content, or notification timelines beyond FCRA. One practical consideration for credit screening in Louisiana: the state has lower average incomes and higher poverty rates than the national average. Credit scores across much of the state's population tend to be lower than national norms. Setting credit score thresholds calibrated to Louisiana's local market conditions rather than importing national standards ensures you don't exclude otherwise reliable applicants. Understanding the local credit landscape helps you set realistic criteria. Louisiana's fair housing protections are found in the Louisiana Equal Housing Opportunity Act, Louisiana Revised Statutes Title 51, Chapter 12. The Act prohibits discrimination in housing based on race, color, religion, national origin, sex, disability, and familial status, mirroring the Federal Fair Housing Act. Louisiana has not added additional protected categories such as sexual orientation, gender identity, marital status, age, or source of income beyond the federal baseline. The Louisiana Attorney General's Office and local fair housing organizations investigate complaints. While Louisiana's enforcement environment is less aggressive than northeastern or west coast states, federal fair housing enforcement is active. HUD and the Department of Justice pursue cases in Louisiana, and private fair housing organizations conduct testing and file complaints. New Orleans has enacted a local non-discrimination ordinance that includes protections based on sexual orientation and gender identity. Landlords in New Orleans must comply with the broader local protections. Screening decisions that appear to target applicants based on sexual orientation or gender identity can result in local enforcement actions, even though state law doesn't explicitly protect these categories. One aspect of Louisiana's legal framework that's unique and relevant to screening: the state's civil law system. Unlike the 49 common law states, Louisiana's landlord-tenant relationship is governed by the Civil Code rather than a common law framework. The lease is treated as a specific type of contract, a lease or hire of things, under Civil Code Articles 2668 through 2729. The Civil Code provisions establish the rights and obligations of lessors and lessees, rather than landlords and tenants. While this terminology difference doesn't dramatically affect the screening process, it means that Louisiana's legal framework interprets lease provisions and landlord-tenant obligations through a civil law lens that differs from the common law approach used everywhere else. Louisiana also has the concept of tacit reconduction, where a lease automatically renews on a month-to-month basis if the tenant remains in possession after the term expires and the landlord accepts rent. This isn't directly a screening issue, but it highlights the importance of thorough initial screening, because once a tenant is in place and the lease reconducts, the landlord-tenant relationship continues until properly terminated. From a practical standpoint, Louisiana's rental market is affordable and diverse, with distinct regional dynamics shaped by the state's unique cultural geography. New Orleans is the state's most distinctive and complex rental market. The economy is driven by tourism and hospitality, including the French Quarter, the convention industry, and the restaurant scene, healthcare, including Ochsner Health System, the state's largest private employer, and Tulane University Medical Center, the Port of New Orleans, higher education, Tulane, Loyola, Xavier, the University of New Orleans, and Dillard, energy industry offices, and a growing technology and film production sector. New Orleans' rental market was fundamentally reshaped by Hurricane Katrina in 2005. The destruction of housing stock, the displacement of hundreds of thousands of residents, and the subsequent rebuilding effort transformed the city's rental dynamics. Many neighborhoods have been rebuilt with newer housing stock, while others, particularly in the lower Ninth Ward and parts of New Orleans East, still bear the marks of the disaster. Rents increased substantially during the recovery period as demand outpaced the rebuilding of supply. Screening in New Orleans requires sensitivity to the city's unique circumstances. Many long-term New Orleans residents experienced Katrina-related disruptions that affected their credit histories, rental records, and employment histories. Gaps in rental history from 2005 and the years following may be attributable to the hurricane rather than tenant fault. While Katrina was 2 decades ago, its effects on credit and housing records can still appear for some applicants, particularly older residents. New Orleans' hospitality workforce represents a huge portion of the rental market. Many hospitality workers earn tip income that may not be fully reflected on pay stubs. Having a clear method for evaluating tip income, such as accepting tax returns or employer verification of average earnings, ensures fair evaluation of applicants in the industry that drives the local economy. The military presence at Naval Air Station Joint Reserve Base New Orleans and the various Reserve and National Guard facilities generate some rental demand, though not on the scale of major active-duty installations. Baton Rouge, the state capital and second-largest city, has a moderate market driven by state government, Louisiana State University, healthcare, including Our Lady of the Lake Regional Medical Center and Baton Rouge General, petrochemical industry operations along the Mississippi River corridor, and a growing technology sector. LSU's large enrollment creates significant student rental demand near campus. Screening students with limited credit and rental history requires consistent cosigner or guarantor policies. Baton Rouge's rental market was temporarily affected by the August 2016 floods, which damaged thousands of homes and displaced many residents. Similar to Katrina's effect on New Orleans, flood-related disruptions may appear in some applicants' housing histories. Shreveport, in northwestern Louisiana near the Texas border, has an affordable market driven by healthcare, including Auctioner LSU Health, Barksdale Air Force Base, gaming, and regional commerce. Barksdale AFB generates significant military rental demand in the Bossier City and Shreveport area. Military tenants from Barksdale provide reliable and verifiable income. Landlords should understand military income documentation, leave and earning statements, and BAH rates. Barksdale's BAH rates are modest, reflecting the area's affordable cost of living. Lafayette, the hub of Acadiana and the heart of Cajun culture, has a market influenced by the oil and gas industry, healthcare, and the University of Louisiana at Lafayette. The energy industry creates cyclical demand. When oil prices are strong, Lafayette's economy and rental demand improve. During downturns, the market softens. Landlords in Lafayette should understand the energy cycle and calibrate screening standards accordingly. Lake Charles has been significantly affected by hurricanes, including Hurricanes Laura and Delta in 2020, which damaged substantial portions of the city's housing stock. The rebuilding effort has affected both supply and demand, and screening applicants displaced by hurricanes requires the same sensitivity discussed for New Orleans. Monroe, Alexandria, Houma Thibodaux, and other mid-sized Louisiana communities have affordable markets with moderate demand. The petrochemical corridor along the Mississippi River between Baton Rouge and New Orleans includes communities where industrial employment drives rental demand. Fort Polk, now Fort Johnson, near Leesville, is a major Army installation that generates significant military rental demand in the Vernon Parish area. Military tenants represent a large portion of the local rental market. BAH rates for Fort Johnson are modest. One best practice for Louisiana landlords, given the state's vulnerability to hurricanes, develop screening criteria that account for disaster-related disruptions in applicants' histories. An applicant whose credit score dropped or whose rental history has gaps due to a hurricane is in a fundamentally different situation than an applicant whose problems are self-inflicted. Having a documented approach to evaluating disaster-affected applicants, considering whether credit issues or rental gaps are attributable to declared natural disasters, demonstrates fairness and broadens your qualified applicant pool. Another best practice: even though Louisiana imposes virtually no screening restrictions, develop a documented screening policy with specific criteria. Louisiana's diverse population and significant minority population make consistent, documented screening practices essential for federal fair housing compliance. Specify your credit score threshold, income-to-rent ratio, rental history requirements, criminal history evaluation standards, and how you handle applicants with limited credit files. Apply those criteria uniformly. A third best practice: for landlords in New Orleans and Baton Rouge who screen hospitality workers, develop a clear and consistent method for evaluating tip income and variable income. The hospitality industry is central to Louisiana's economy, particularly in New Orleans, and automatically rejecting applicants whose base pay appears low without considering total compensation, including tips, excludes a large portion of otherwise reliable tenants. Louisiana does not have a statutory cap on security deposits. The deposit amount is governed by the lease terms, giving landlords flexibility. The deposit must be returned within 30 days of the tenant vacating. If the landlord fails to return the deposit or provide an itemized statement of deductions within 30 days, the landlord may be liable for penalties, including the wrongfully withheld amount plus damages. While the flexibility on deposit amounts provides financial protection, thorough screening remains the most effective tool for tenant selection. For the complete guide to Louisiana tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.